It's a little crazy with the kid and the dog.
I can't get my video to work today.
That makes me look adventurous.
Oh, sorry.
Oh. I know. Oh no.
That was so bad. That was so bad.
Hi, everyone. Thank you so much for joining us today for our Chapter 13 session. So we're going to get started here in just a few minutes, but first I just want to go through some quick housekeeping. So let me share something really quickly. I hope you're all having a great day. We've had so much feedback and excitement over this, so we're really excited to have some of you join us again today. 1 second, let me find this link really quickly. Okay, so I will be introducing our speakers shortly, but while we wait on everyone to join and get in here, please take a look at the Code of Conduct to ensure that we're just following community guidelines and make this a safe and inclusive space. So to read that full statement, you can see the link that was just posted by our community moderator. So that's going to be in the chat to the right. And then I'll give you just a brief moment to review that and go over that. And then while we are waiting still for everyone to join, I'll give you a few moments to review that. And then please just take a moment to get familiar with the chat, the questions, and the polling functions for today's session. So our community moderators are Mandy Ballinger and Sarah Taylor, who will be posting relevant information and links into that chat. They'll be answering questions and they'll be posting polls too. So please use the chat to communicate with other attendees and then inform us of any technical issues you may have. I also just have a few housekeeping notes. We learned a lot yesterday, so we just want to let you all know, like, we've had a full house for our previous Bankruptcy Week sessions, and I just want you to know we're recording every session. So these are all going to be recorded, and we will post them to our Next Chapter YouTube page later today. We're also going to email you all with the link. So if you're experiencing any connectivity issues, you'll have access to everything later, but also just try closing out of other programs and tabs on your computer. You can even leave the event and come back in. We do have limited seats though, so if you have to do that, you can't get back in, it's okay. We'll get you to everything later. And then we've also just been told that sometimes Chrome works better than other browsers. We also have a free Slack group for you to continue this conversation that we've created. It's open to all Bankruptcy Week attendees, and we encourage you to join in and network. So there are channels broken out by region, and already a few hundred people have been chatting. So we'll include that link for to that in the event email recap later today. We're also just going to keep posting it throughout the session as well. The chat is crazy though, so it might get lost. So just look for anything from Mandy and Sarah. Then you might see some other people from Next Chapter in there chiming in as well. So now that that's done, we can get started with the fun stuff. So thank you so much again for joining us today for Chapter 13 Bankruptcies with Athena Inembolidis. My name's Katie. I'll be your MC. In just a minute, I'll invite Athena to take over and she can go over everything you need to know about Chapter 13 bankruptcies. But first, we just have a few stats to go over. So since the pandemic has started, 3 million people are not paying their mortgage. 1 in 4 small businesses have shut down. 22 million people have filed unemployment. We know that number is going up consistently. And then during the last recession, bankruptcy filings went up 74%. So that's kind of why we came up with Bankruptcy Week, because the economy is not going to be the same when we get through this. So as a legal software company in the bankruptcy space, we've seen firsthand the data represented by the ebbs and flows of the economy. During the last recession, like we said, bankruptcy filings went up 74%. And commentators are predicting a tsunami of filings coming after this pandemic is over. So attorneys need to be prepared. So this week is all about helping you learn bankruptcy and how to better your practice through marketing, software, social media, client payments, workflows, and more. So I want to give a brief introduction about our next speaker, Athena. So Athena is founder and managing attorney at Athena Legal in Columbus, Ohio. She received her JD from the Cleveland Marshall College of Law and her undergraduate degree in international studies from Baldwin Wallace College. Athena started her practice in 2008 to represent Chapter 7 and Chapter 13 debtors who were in need of financial relief. She's been a board member of the Credit Education Coalition since 2012 and is the president-elect. Athena received the In the Trenches Award from the Legal Aid Society of Columbus in 2019. And in her spare time, she enjoys traveling, writing, and performing improv. So I am going to now invite Athena to the stage where we can give her a warm welcome, and I will leave her to present to you all. So she's coming on now. We'll give her 1 second to join, and then we can get started with the fun stuff.
Hey.
Hi, how are you?
Great. How are you?
Good. It's nice to see you.
Nice to see you too.
Thank you so much for joining us today. And then I'm going to hop off, but I'll be back in about 40 minutes and we can go over all of the top rated questions from everyone.
Awesome. Thank you.
Okay, awesome. Good luck.
All right. Thanks. Hey, everyone. Thanks so much for joining us today and to Next Chapter for inviting me to speak to all of you. I wanted to let you know that I initially started hating Chapter 13 practice. Like, I was terrified of it, wanted nothing to do with it. But as time went on, I realized that there was value to it and it was important to do. So I'm about to show you my, okay, can everybody see my PowerPoint here? Improve my lighting. Sorry, I don't think so. Okay. Oops. Okay, so. Okay, so my presentation is why I fell in love with reorganization relief. Cool. All right, so this was me in the beginning. Note the terrified eyes, but the outwardly calm look. I was an attorney, so of course I never wanted to show my poker face, but inside I was dying, up all night, worried about all my Chapter 13 cases, if I'm totally being blunt with you. And sleep is really important. If any of you are not into it, it's a really good thing for your health. So there was a combination of this lack of sleep and stress about what happens in Chapter 13 cases. So I want to tell you that, yes, there is hope, and Chapter 13s can be learned easy, a great remedy for your client, and profitable for you. So it takes a little bit of time and practice to get there, but these are all true things. Okay, so first question is this you? This Chapter 13 suck? Change my mind. And you probably want some more, oops, pardon me, let me go back. If you want me to change your mind, I probably need to give you more evidence because a lot of you are attorneys and that's how you operate. Okay, so the first big key about Chapter 13s is that technically a Chapter 13 debtor is a debtor in possession. So that's code section 11 USC 1303. I don't know if I can enlarge my slides. If Katie is in there, Janine, if there's somebody that can help with that part, if there's a way to do that. So like I said, code section 1303, this is one of the biggest keys of why you would want to be in a 13 at all. So what this means is that your debtor keeps control of the bankruptcy way more than a Chapter 7. In a Chapter 7, it's hands off, and whatever happens with the Chapter 7 trustee, that's basically it. You just have to go with it. Whereas in a Chapter 13, the debtor retains control of how to move the case along through the process. Of course, there are certain things that have to happen, like 341 meetings and confirmation hearings and such, but I will get into more detail here what this means, debtor in possession. Okay, so the types of powers that the Chapter 13 debtor receives are under 363B, which is to use, sell, or lease property. And then also 363F, which means that they can sell property free and clear of any interest if any of these following 5 items apply. It's okay, I see that there's a thumbnail issue, perhaps. Okay. So, oh, there we go. Is that better? Can everybody see? Okay, cool. Thank you, Katie. All right. So one of the things, I may be getting a little ahead of myself here, but as far as the powers related to what a debtor can do, I'd like to point you to 363F5. I had a case where my client had a piece of real estate that had 2 liens on it, and he had an offer to sell the real estate, which completely covered the amount of the first mortgage and part of the second, and the creditor objected, and the judge ended up ruling in our favor and allowing the sale to go through, even though it was a short sale under section 363F5, because it would lower the amount of deficiency balance, which would overall allow more for the unsecured creditors. Okay, so powers continued. The other powers that the trustee has is, pardon me, not the trustee, the Chapter 13 debtor, is the ability to sell, use, or lease property. You usually have to get permission to sell or lease new items, but there's usually a process in place for that. But again, the trustee can, good grief, the debtor can sell their real estate. They can purchase other real estate. They can sell vehicles. They can purchase other vehicles, etc. Whereas in a Chapter 7, the trustee can sell out property from under you. So Chapter 13 allows Chapter 13 debtors to remain in control of their assets. Another great thing that happens in Chapter 13s is that you may convert the case to a Chapter 7, and conversion is done by notice, not by motion. And you can do this when there's a change in circumstances for the debtor. So you may have started in a 13 and want to convert to a 7. You may also dismiss, which is under 1307B. So the debtor has a right to voluntarily dismiss their Chapter 13 case at any time, as long as it wasn't previously converted from Chapter 7, 11, or 12. And the reason for that is, if you were, let's say you had a Chapter 7 debtor who was in a case where there was an asset that the trustee was trying to liquidate, and you ended up converting, oh, I see that it's done by motion in a few courts. Okay, please also know that these are things that may vary from district to district. And yes, you can convert to a 7. If there's a change in circumstances in our district, then we're able to. And some districts may not have an issue with the means test. I think that varies from state to state. So as far as the dismissals, the Chapter 13 cases can get dismissed. So getting back to that example, if you had converted from a 7 to a 13 to protect an asset, dismissing at that point is not just automatic, because you may have been trying to avoid the sale. Okay, all right. So the other reason that you would want to do a Chapter 13 is for the mortgage benefits. So, oops. Is for the mortgage benefits. Can everybody hear me? Okay. Thanks. Sorry to. You can set up your Chapter 13 plan to have the trustees disperse the monthly payments on your behalf. The reason you would do that is to allow your debtors to consolidate all their bills into one payment so they don't have to manage all that. You also know that the payment is made completely on time because the trustee is dispersing it. And there's also a very clear record of when each of those mortgage payments are made. And that's very important should you have an issue after discharge for if a mortgage company is trying to collect from your debtor or say that they're behind, you have a very clear record that is admissible in court that you can use to back up your client. Another great reason is to cure mortgage arrears over 60 months instead of a lump sum if they fall behind. You can also cram down mortgages secured by property that is not the debtor's principal residence. You can also pay off your primary residence over the life of a plan if the last mortgage payment is due before the final payment is due. So an example of that is I had a case recently where my client had a balloon payment. I also had another one where the client had she wanted to refinance her property, but she wasn't able to because her credit wasn't so good. So we were able to propose that, propose repayment of that loan. She was in the plan long enough where she was able to refinance it. And then you can also avoid defective mortgages under 11 U.S.C. 544. Another key part of the plan is when you have vehicles, and reasons that you would have vehicles in there is so that you can lower plan payments or vehicle payments and spread them out over the life of the plan. You can lower the interest rate. A lot of debtors have 25% interest on their vehicles, and you'd be able to lower the interest rate proposed in the plan to a much lower amount. The case that you need to know for reference for that is in re till, which is called the till rate. And the till rate is prime plus a couple percentage points for the risk that the creditor has for a case that is in bankruptcy. So, so the till rate, I usually propose between 5 and 5.5%. Each of your districts are going to vary. And, but I offer something a little bit lower so that if the creditor doesn't object, I get a better result for my client, or if the trustee doesn't object, I get a better result for my client. Now, the other thing to watch out for when you're looking at car matters is that your client may actually have a better rate than 5 or 6 or 7%. Some districts require you to use a till rate, and some places allow you to keep the contract rate that they originally had with the original creditor. So make sure that you're getting the financing statements from each of your clients and reviewing those documents to see what interest rate they're actually getting. Okay, now there's another item called cramdown, which if a vehicle was purchased less than 910 days ago, you have to pay back the full amount of whatever is owed on the bankruptcy. However, if the vehicle was purchased more than 910 days ago, which is 2.5 years basically, you can do something called a cramdown, where you only pay back the secured amount, the value of the vehicle. So let's say the vehicle is worth $10,000 and the client owes 15. Instead of paying back $15,000, the client would only pay back 10,000. And that's only available for vehicles that are more than 910 days old. Same thing with personal property. So the personal property is also secured, maybe secured debt, and you can use that to lower monthly payments, lower interest rate, and to cram down how much the secured debt needs to be paid. So in the look back year is a year for personal property items. So this would be things like random furniture, refinanced cars. So if your client, if it was non-purchase money security, you have a 1 year look back instead of a 910-day rule. I had a client recently with a vacuum and other miscellaneous personal loans. Okay. Okay, another great reason to file a Chapter 13 is if your client has domestic support obligation arrears that aren't being paid already through wage deduction. You can also reject or accept executory contacts or unexpired leases and use the Chapter 13 plan to catch up those items. Okay, so this is one of the biggest benefits of Chapter 13, and my caps on this page are intentional. You can remove a wholly unsecured mortgage, which means that if you have a, let's say, a property that's worth $100,000, and the first mortgage is the total balance is, let's say, $110,000, and you have a second mortgage that has a $30,000 balance. You can file, in our district, it's a motion. Some places it needs to be done by adversary proceeding, but you can remove that second mortgage from the real estate and have it paid back as an unsecured claim. And the reason that's important is often the unsecured claims, you pay back pennies on the dollar as opposed to the full amount with interest. So it's a huge, huge, huge benefit to mortgages. And right now we have a booming real estate market. So this isn't coming up as often, but if and when the economy crashes or the housing market crashes, this will be coming up more often for you. And just be mindful to look for it. Also, you will need an appraisal. Again, in our district here in the Southern District of Ohio, you'll need a formal appraisal, which you can order and append to your motion. Okay. Often you can do lien removals of judicial liens in Chapter 7 bankruptcies. You can absolutely do them in Chapter 13s as well. And as a practice point on this, just please make sure that you're capturing, looking for lawsuits, looking for the judgment liens connected to them, and filing the appropriate motion or adversary proceeding to remove those liens so that your clients don't have to deal with them and it's not a headache for you after. Okay. Another thing you can do is surrender property. And what happens with surrendered property is the creditor will take it back, sell it at whatever auction, foreclosure, etc. And then the deficiency balance becomes an unsecured claim. And again, same reason as earlier that we talked about, that unsecured claims get paid back at a smaller rate than the secured claims. Okay, another fantastic result through Chapter 13 is that you can include taxes, income taxes, non-dischargeable taxes that are that need to be paid. There are taxes that will not be dischargeable in any situation, typically trust taxes or taxes for claims that have not been, or taxes that have not been filed ever. And the tax discharge process and analysis is a very complicated thing. And you could probably have a seminar on that for days and days and days and still not have scratched the surface on it. However, what to take away here on the tax matters is that it forces the IRS into a repayment plan with your debtor. So if your debtor owes more than $10,000 or $15,000, there isn't any sort of offering compromise situation. You just want to make sure that that your debtor can afford to pay back the taxes over the course of 36 to 60 months. It also protects your debtor from any sort of levies, collection activity, IRS scary processes. But not everything gets discharged, and please be aware that your client may come out with some owing some tax debt in the end, but the 13 is a great remedy for managing it as best as possible. Okay. Additional reasons to file a Chapter 13. You can use the Chapter 13 to impose the automatic stay when your client needs it, even if the debtor is not eligible for a Chapter 13 discharge. And you can use the Chapter 13 to do any of the things that we talked about above, even if the client is not eligible for discharge. Debtors may file a Chapter 13 and receive a discharge if they complete their plan, if they filed Chapter 7 at least 4 years ago. And it's filing date to filing date. So some clients need the bankruptcy relief before their 8-year period is up to refile a Chapter 7. You may be able to get them into a low Chapter 13 repayment plan where they're at least protected, the payments are manageable for them, and they're still getting the relief that they need. Okay. Also, there are certain things that are dischargeable in a Chapter 13 that are not dischargeable in a Chapter 7. So if you look at 11 USC 1328, which is the discharge section, the exceptions to discharge are listed specifically there. Sections 1B and 1C are related to tax matters. Section 2 is related to false pretenses, debts incurred under false pretenses. Section 3 is unlisted debts. Number 4 is fraud as a fiduciary. Number 8 is student loan debts are not dischargeable yet, hopefully in some point soon in Chapter 13 or 7, unless you go through the possibilities of filing some sort of adversary proceeding. Our district is very strict on the terms of that, so we don't have a lot that get through here. So those of you who do, wonderful. And then finally, number 9 there is debts incurred as a result of intoxication, injuries incurred that you caused because of intoxication. Okay. Now, so that means that sections 523A6, 7, 10, 11, 12, and on are dischargeable in a Chapter 13. And one of the most important ones to note here are debts related to a divorce decree. So not child support, not domestic support obligations, those are still not dischargeable. However, if you have a debtor who had a joint debt with a former spouse and your debtor was court ordered to pay that joint debt, let's say to Chase, as a pursuant to the divorce decree, that debt may be wiped out in a Chapter 7 as to your debtor and Chase, but the ex-spouse may come after your client for contempt of court for not following the divorce decree. Whereas in a Chapter 13, it protects your debtor from the contempt matter against the former spouse. So that's a huge thing to look out for. If you have a debtor that's been divorced, confirm that there aren't any joint debts that were court ordered to be paid in a divorce decree. DSOs are not dischargeable. So this is a slightly different nuance there. So if you owe child support, that is not dischargeable. Very, very definitely not dischargeable. What I'm talking about is debts related to joint debts. Okay, so this is probably the part many of you were waiting for. Why on earth would I want to file a Chapter 13 for people? One is for cash flow. And I want to be very clear that by filing Chapter 13 cases, you will never be as wealthy as Mr. Wonderful. So please keep that in mind as we go through here with his picture. But they are way more profitable than Chapter 7s. So typically, and again, this is district to district, but in our district here in Ohio, we've got our Chapter 7 fees are typically around $1,000. And we have something called a no-look fee that is, for Chapter 13s, that's a minimum of $3,700. So right there, you have almost triple the amount of fees for the case. And a lot of the work is the same. So preparing a petition is basically the same in a Chapter 7 as it is in a 13. There is additional work you need to do in a Chapter 13, like preparing the plan, reviewing all the claims, etc. And each no-look fee has different requirements in it, pursuant to local rules typically. But just be mindful that the amount of fees that are in the available pot are bigger. The other thing that's really nice about Chapter 13s is that you're able to defer some of the filing fees to make it more affordable for debtors to get relief. So you may accept $500 upfront and then have the remaining Chapter 13 fee paid in their Chapter 13 plan. You can also charge additionally for additional services. And here we do an application for compensation for the work that we've done related to the case. And if the court grants it, then it gets paid through the Chapter 13 plan. You also have the option to either do a flat fee in the Chapter 13s or bill hourly. And there are most attorneys opt for the no-look fee because you have to file fee applications if you're charging hourly. But charging hourly is a great way to know exactly what you're doing, how long it's taking you to be paid for the time that you're actually spending. And also you have more client control that way because, lots of clients are very anxious and understandably so, but I spend lots of time. I spend more time than my actual no-look fee justifies. So keep that in mind. Okay. Okay, did you become a lawyer to avoid math? And if so, I'm sorry, because the Chapter 13 requires some math. All right, so now we're getting into plan math. And please pardon my Venn diagrams here. I spent like an hour trying to figure out how to make these not shaded and to shade only in the certain spot. So what you're looking at here are the 3 circles of how to calculate a plan payment, what you need to look at. So one item is the budget surplus. The other item is the secured debt payments that must be repaid. And then the other is the unexempt equity that is not protected in a Chapter 7, then gets calculated as unexempt equity in a Chapter 13 setting. And so where these circles overlap is where your sweet spot is of what your plan payment needs to be. And I'll get into some examples here in just a moment. Okay, so you start with secured amounts. So I ask, is there a mortgage? So first is, if it's yes, find out if it's current. If it is current, our district allows you to keep the current mortgages out of the plan. And Reasons to keep it out is that the trustee charges a fee to pay those creditors on your client's behalf. So if you're worried that your client may be inconsistent about the payments but is currently current, you may want to put it in the plan so that you have a good record of it later, or so that they don't fall behind mid-plan and then you're scrambling to try to figure out a solution mid-plan. Okay, so then you go to, is there a mortgage? Yes. Is it behind? Yes. Find out how far behind you are, or not you are, your clients are. Hopefully you're not behind on yours. Find out how far behind. Find out if escrow is included in the monthly payment and add that total to column A. One practice pointer is if you have a recent mortgage statement from your client, it's helpful to see how the creditor is calculating the arrears. And then you have a better idea of how much is actually owed. Sometimes clients don't have a record of this stuff and you just have to guess. What I do is if they don't have any record of it, I will say, okay, when do you remember the last time you paid it? And then I calculate how many months that's been since we go to file. Looking back, multiply it times the mortgage payment and add that to my column A arrears. Okay. Now, the next thing is there a vehicle? And you're going to repeat this step for every item, every vehicle that is in your client's possession that they want to keep. So first of all, find out, is there a lien on the vehicle? And if so, was it purchased less than 910 days ago? If so, take that total balance and put it in column A as well. If the vehicle is free and clear, see if there's any unexempt equity that you need to account for in that matter, in that situation. And just keep a side note of that. You will also do that for any other secured debts, so jewelry, sheds, vacuum cleaners, etc. And add anything that your debtor wants to keep into column A. Okay. Going back quickly to the is there a vehicle section? If the vehicle is more than 910 days old, what you want to put in column A is the amount of the value of the vehicle. So like we talked about earlier, if the car is worth $10,000 and 15 is owed on it, just put $10,000 in that column A. Okay. And then also, if real estate taxes are not included in your client's escrow or mortgage payment, make sure that you confirm that they are current on their real estate taxes. If they are not current, you can add that amount to column A as well. Okay, then the other thing you want to add to column A is priority claims. So any taxes, child support, any other priority claims. You also will want to add any remaining attorney fees to column A. And I try to estimate if there are going to be additional fees in this case. And I try to buffer that calculation. Like if I know if I have a lien strip or whatnot, I'll estimate how much I think it's going to cost me to do that. And I add that to column A as well. Okay. Then I add the non-exempt equity to column A. And your petition preparation software will tell you if you have unexempt equity. And this determines your best interest dividend. So the best interest dividend is the minimum amount that needs to be paid to your unsecured creditors based on the claims. So what you're going to do, so I've given an example here. Let's say that the unexempt equity is $5,000 and the total unsecured debt is $25,000. So you'll divide $5,000 by $25,000, and that will give you 20% as a best interest dividend. So over the life of the plan, you have to pay that much to the unsecured creditors. So you'll put that in column A as well. Then you want to so you have your column A numbers. You want to multiply the interest rate for the secured claims. So on a car, for example, you'll want to add whatever the interest rate is. So like I said, I usually use around 5 or 5.5, and then add the interest to the column A. And then you divide the total by the percentage that your trustee charges in your district. So if your trustee charges 10%, you want to divide by 0.9. So that's the percentage. And then you divide that total by 36 or 60 months to get the monthly payment of that portion. And then you want to go to the PERMOs, which is the per month calculation. So Conduit Payments, if you have a mortgage running through the plan, anything that has a fixed payment amount that the trustee must disperse, you want to do the same division thing where you divide by the percentage of your local trustee. Okay, so here's my calculation key. So if we have 17,000 in arrears, in mortgage arrears, vehicle plus the interest, tax, remaining attorney fees, and the non-exempt equity example leaves about $37,000 in column A. And then here I have a mortgage, just one mortgage running through the plan, which the monthly payment is $1,375. So here's the calculation again. So you can refer to that chart, and once you work the numbers, you'll understand better how to calculate that. And like I said earlier, your below median debtors have an applicable commitment period of 36 months. They can take up to 60 months to complete their plan, whereas a above median debtor has to be in the plan for 60 months, but can be in it for less time if they pay back all of the debt. Okay. Another thing to consider while you're doing the calculation. So the number that you just got on that previous slide is what the minimum has to be. But if your debtor makes a lot of money and has extra surplus in their budget, you may end up having them pay more into the plan because they just can afford it. Another tip is if the debtor is short and their budget doesn't really work so well, you can do step payments if they're planning to have, maybe they had a short-term job loss, but will be increasing their income later. You can make a step payment in the plan. The other thing that you can do is have them infuse their tax refund money over the life of the plan. So that helps supplement the funds, and then allows them to have a lower monthly payment. Okay, so you want to make sure that your clients know that they need to make their plan payment within 30 days of filing, and have them be in touch with you if anything changes. That's very important. If anything, their income increases, decreases during the plan, they get into an accident, they want to sell something, buy something, inherit money, etc. And then another thing to keep in mind is that you want to confirm the cases at confirmation to make sure that the secured claims, like mortgages and vehicles that the debtors want to keep, have filed claims. The priority debts as well, or non-dischargeable claims, like for student loans, have been filed. You are allowed to file the claims proactively on behalf of your debtor if the creditor has not done so. But please don't do that for things that, like, you snooze, you lose kind of stuff. So if a random credit card doesn't file a claim, you don't need to do that for them. That claim just gets discharged like the rest of them. I've also offered here some how to review claims, because that's another thing that you'll need to do once you file your Chapter 13 for your client. The review for unsecured claims is a little bit more simple than the claims that are for secured items, but they're straightforward, and you can object to the claims if they're not right, or if they don't appear right, or if they're for debts that are too old. For mortgages, you want to look at those very carefully, because a lot of errors can happen in the mortgage calculations. And the creditors are supposed to append the details of how they came to the arrearage number. So you want to comb through that and make sure that that's accurate. Okay, same with taxes. Sometimes the IRS estimates the claims. If the debtor hasn't filed their taxes, you'll want to get your clients to file the taxes so that they can adjust the amount owed instead of the estimate. So you'll just object to that as well. And there are just some bullet points on that.
Hi. It's me.
Hi, sorry.
Back.
Or too much. Okay, sorry.
No, you're fine. There's just so many good questions. I want to make sure we have time to go over them. So
Okay.
it looks like you have what, 3 left. So I'll just hang out for a minute and then we can
Okay.
go over the Q&A.
Okay, cool. All right. So let me just, so there are best practices here, and there are reasons that the Chapter 13 can be frustrating. There are a million reasons, but the good outweighs the bad. And I don't know if anybody likes Sword in the Stone, but this is one of my favorite scenes ever in every movie. You are able to learn this stuff. Ask questions. The Chapter 13 trustees are welcome to help. They love helping because they want to make sure everything moves smoothly. And your colleagues as well. And you're welcome to reach out to me if you have additional questions. And it's a great remedy. So just don't let fear get in the way of you helping your clients to the maximum. That's it.
Well, thank you.
All right.
I think what you've taught us all is that Chapter 13s are not easy, but you gave a lot of great insight. So thanks so much. And we had a ton of questions. So I have a few of them collected.
Okay.
So, okay, for one, we had an attorney from Maryland chat us, and he said, in my jurisdiction, we can deduct anticipated cost of sale in arriving at non-exempt equity. Trustees and judges accept this. Do you ever try this where you are?
Yes.
Okay.
Yeah, it's a great thing to do because it lowers the amount your client needs to pay.
Awesome. Okay, good pointer.
Mm-hmm.
We got asked this a lot. So can you please explain briefly again what a cramdown is?
Yes. So cramdown is when you pay what the car is worth instead of the total amount owed.
Okay.
So I don't know if that's clearer. If that's not clearer, please chat in the chat feature, and I can try to elaborate more on that.
Okay, cool. What are some initial factors in determining whether a client's eligible for a Chapter 13 or a Chapter 7?
So initial factors would be if they're above median, that's a big one. If they have assets that they want to keep but don't have enough exemptions to keep in a Chapter 7. If you're concerned about liquidation in a Chapter 7, those are the 2 main reasons I would file a 13. Or if they're behind on cars or houses. Those are the main 3 reasons.
Okay. So how do you go over those initial evaluations when you're like determining what to put your client, which chapter to put your client in?
I analyze those 3 questions separately. So I usually start with the income matter, because if they're above median and I can't get them into a 7, even if they want it, the conversation stops there. Like that's the clearest and easiest one to use. Then if they're behind on a mortgage, I ask them if they're able to catch it up so that we can file a 7. If they say no, then that also bumps them into a 13 because they want to keep an asset that they wouldn't be able to keep if they file Chapter 7. And then third matter is if they have, typically this happens in the setting of cars, like somebody will have a vehicle that's free and clear, and Ohio's exemptions are not that great. So I had a client actually that I filed last week that he had paid off his car note, and it was like a newer car with very few miles on it. So it was worth like $15,000 and our exemption's only $4,000. So that bumped him into a 13.
Okay. Are you noticing a lot right now, like that you're having to analyze when people are going to file?
I'm sorry, can you say that one more time? I just realized the sun's coming through. Yeah.
Everything going on right now, like how are you determining when your client should file?
That's a tricky one. I've been asking how secure their jobs are. And I'm trying to bump out some of the 13s a little bit to not file them quite yet because everything's just up in the air.
Mm.
And I filed probably 5 13s in the last month or so. One of them, two of them actually already have furloughs and issues. So if you can wait a little bit, it'd probably be best.
Okay.
Yeah.
I think you kind of briefly went over this, but someone asked, how do you structure your fees on your 13s?
So I typically take the no-look fee. This is something that I've been going around and around with myself on whether I should start charging hourly, because I know that I put more than $3,000 or $4,000 of work into these cases over the life of a plan. And our no-look fee here is $3,700, and I just build it into the monthly payment through that calculation that I did at the end.
Okay.
Yeah.
Are you allowed? I mean, this is just me asking a question. Are you allowed
Sure.
to do both?
Are you allowed to what?
Like, can you do some no-look and some hourly?
Oh yeah.
Okay.
Yeah, it's just you can opt in or out per case.
Gotcha. Okay, last question. So if a client files a Chapter 13 and I know that the client isn't eligible for discharge, isn't that fraudulent or frivolous?
No, because they may need the 13 for the automatic stay protection. So, or to catch up a mortgage arrears. So you don't need to get a discharge in a 13 unless the client needs a discharge. So, let me give you an example. If somebody is not eligible for a Chapter 13 discharge because they've had a Chapter 7 too recently, if they have more unsecured debt, then I will try to put them in a 100% Chapter 13 repayment so that they actually pay all the debt back, but on their terms. Or if it's just for mortgage arrearages, then I just structure the plan for that. A lot of people sometimes don't use credit and don't actually have unsecured debt, but because they've had a 13 or a Chapter 7 in the past that wiped it all out. So no, that's actually a very valid reason to file a 13 if the debtor needs it for some other reorganization purpose.
Okay. Awesome. Well, thank you again. I learned a bunch today, so that's cool. I can't practice it, but still. So thanks so much for taking the time. That was super helpful. I'll let you go. I'll finish up with a few things here, but hope you're staying safe out there. You're right down the road from us, but yeah, we'll talk soon.
All right. Thank you. Have a great day, everyone.
Bye, you too.
Bye.
Okay, so I'm going to wrap up here. We have another session coming up at 2 p.m. today. It's a Women of Legal Tech panel. So you can go, I'm sure the link was shared a bunch of times, but it's also on our website. Feel free to register for that. Athena's recording and slides will be sent to you all later. And then thank you so much. We'll see some of you in an hour, hopefully. And I am signing off now. So bye, everyone.